Thank you. Please take your seat. Ms. Larkham, would you like to come forward, please? Thank you. Just, yes, remain standing. Would you please state your full name?
Jermaine Mary Larkham.
Thank you. Would you like to take the oath or the affirmation?
Affirmation, please.
Please read out aloud the affirmation.
I, Jermaine Larkham, sincerely declare and affirm that the evidence that I shall give to this Commission shall be the truth, the whole truth and nothing but the truth.
Thank you very much, Ms. Larkham. Please take your seat and make yourself comfortable. Yes, Ms. Seawood.
May it please the Commission. Ms. Larkham, you are the current Executive Director, Racing, Gaming and Liquor, and the Chief Casino Officer in the Department of Department of Local Government, Sport and Cultural Industries.
That's correct.
And you received a witness summons to appear at this Royal Commission.
That is correct.
And you received a list of questions and a request for a witness statement. Now,
Yes.
in front of you, there should be a piece of paper. Does that look like the witness statement you prepared?
Yes, it does.
And if we turn to the last page, is that your signature?
Yes, it is.
I can see it doesn't have a date there. Can you remember what date you signed it on?
That was Tuesday the 31st.
And it wasn't witnessed. Can you just explain to the Royal Commission the reason for that?
I was working remotely from home on the 31st.
And if I can just take you to turn back to page 11, I think that's the last full paragraph, and that's number 53.
Yes.
Now, you identified a correction you would like to make to your statement.
Yes, that's correct.
I believe it's in paragraph 11.
Yes, in paragraph 11, in relation to duties, the correction is specifically duties 2, 3, 7 and 9.
So after the numbers 2 and 3, we need to add 7 and 9.
Please.
And is that the only correction you wish to make?
Yes.
So that witness statement with the correction, is that true and correct to the best of your information, knowledge and belief?
It is.
Commission, I tender the witness statement of Jermaine Larkham dated 31 August with reference number DLG.0001.0011.0013.
Thank you, Ms. Seawood. The witness statement of Ms. Larkham with the amendment and bearing that number will be an exhibit in the Commission. Yes, Mr. Lee.
Thank you, Commissioner. Ms. Larkham, I'm one of the counsel assisting the Commission, and so I'm going to take you through some of the questions I have in relation to your witness statement. Firstly, your witness statement explains that you have a substantive position in the WA Public Service within the Department of Water and Environmental Regulation. Is that correct?
That is correct, yeah.
And what is that substantive position at that department?
I am the Director of Regulatory Capability within the Department of Water and Environmental Regulation.
And then at paragraph 4, you explain that you're currently seconded from that role to the Department of Local Government, Sport and Cultural Industries, which I'll refer to today as the Department for ease of reference. And you explain that your secondment commenced on 8 July of this year. Is that correct?
That is correct, yes.
You say at paragraph 6 that the length of the secondment is currently 6 months. Now, by that word currently, do I take it that there is a possibility that the secondment may be extended?
That would be predicated on the interim structure that is currently in place in the department. So right now it is 6 months. Beyond that, I can't really comment.
And are there any projects or other work to which you have been committed back at the Department of Water and Environmental Regulation that would require you to go back at the end of the 6 months?
Not at this, no.
And this may be far too early to tell, but from your perspective so far, given the work that you are undertaking, do you consider that it is likely that you will be able to complete your secondment at 6 months, or that it might be necessary to be extended?
In terms of the position being Executive Director, Racing, Gaming and Liquor, in that position being absolutely, I think the position will be warranted far beyond the secondment that I sit within.
Because, as you've just alluded to, the position was created shortly before you were put into that position. Is that correct?
That's correct, yeah.
Now, paragraph 5 of your statement, you explain that a week after commencing in that role that we've just referred to, the Executive Director, Racing, Gaming and Liquor, you were then appointed as the Chief Casino Officer. Is that correct?
That is correct.
And I'll refer to the Chief Casino Officer generally as CCO today. Now, can I take it by that small time frame, the week between being a seconded and being appointed as CCO, that you would have been aware before you were brought into the position of ED-RGL that you would also be appointed as the CCO?
Yes, I was aware of that.
And can you give the commissioners a bit more of an understanding as to how this came to be in terms of you being brought into that role? Was it something you applied for, were you approached? Can you just tell us about the mechanics?
Of course. I was approached by the then Deputy Director General, Fiona Roach, in terms of an opportunity to second into this newly established position within the department.
And did Ms Roach explain to you what your role would be, what you would be working on?
Yes, before accepting the secondment, I met with both Fiona Roach and Lainey Chopping, who provided me with an overview of the role and the interim structure and gave me a briefing.
And in terms of what your understanding was as a result of that briefing as to what role you would be performing, what was your understanding at that stage?
My understanding that the position of Executive Director, Racing, Gaming and Liquor was responsible for oversighting the regulation of the gaming, wagering and liquor sectors, working in conjunction with the Gaming and Wagering Commission and the team within the Racing, Gaming and Liquor division within the department.
So I'll come back in some more detail to your role in a moment, but before we do, I'm just going to go to your CV, which is referred to at paragraph 2 and 3 of your witness statement. I understand from that CV that your tertiary qualification is a Bachelor of Science with honours.
That's correct.
And your CV explains that you have extensive experience as a government regulator, both in Western Australia and in Ireland, but no prior experience with casino management.
That is correct.
Having looked at that CV, am I right in understanding that your career till now has been primarily focused on environmental regulation and compliance?
That's correct.
And in your more recent career, your roles have been ones with a focus on risk management in compliance.
My most recent experience since probably 2017 has been in strategic kind of regulatory reform roles within the Department of Water and Environment Regulation.
So if we can just go to page 3, please, of this CV, and this is when you were acting as a manager, senior manager, between April 2009 and April 2016. You can see in the 4th dot point down, there's a discussion of ensuring effective risk management and governance.
Yes.
And then if we can go, I think it's to page 4, which is between October 2017 and November 2020. Or it might be page 2, perhaps. So then down towards the second half of the page, the 2nd dot point, you talk there about ensuring contemporary regulatory risk management. Now, the idea of risk management is one that's been referred to in many of the documents that have been put before the PCRC. It's not clear that there's always agreement as to what's meant by that. What is your understanding as to what is involved in risk management as a regulator?
So the majority of my career in regulation has been in the compliance end of the regulatory spectrum. So my experience both as an authorised officer in the earlier part of my career and in the latter half in building and reforming regulatory delivery sees, I suppose, an ability to assess risk relative to the sector that you're regulating in, relative to the element of the regulatory delivery that you're in as a key foundational element of effective regulation. So ensuring that the risks of the sector in which you're regulating. So while you spoke to my experience being predominantly in environmental regulation, I have a range of experience in working across different legislative frameworks, whether it be sustainability, environmental protection, waste management. So understanding the risks relative to the sector that you're regulating in, relative to the objectives of the Act that you are operating under, is incredibly important in ensuring effective regulation.
So that's quite a broad question, but in terms of those previous roles and also the approach that you will bring to your current role, how does one go about identifying the risks that need to be managed in a regulatory and compliance framework?
In considering risk within the sector, you would rely first and foremost, I think, in my experience, might go to the legislative framework very clearly to understand what the objectives are that you are seeking to achieve. And then being very, very clear, I suppose, about understanding the sector risks. So that would be an understanding of the market and what is currently the current operational state of play of the sector. So in respect, I'm trying to think of something that I could use by way of an example. So I would look at current reports, current trends in a sector, not specific to casino in this instance, but I would look to trends in the sector. I would look to historic understanding of the instruments within the sector, so what the regulatory framework looks like, to ensure I have an understanding of the risks within the sector, and then the effectiveness of the regulatory delivery, I suppose, to address those risks.
Now, that process, has that commenced in relation to casino regulation since you've arrived at the department?
Given my relatively short tenure in this role, I think this is my 7th week, that work has commenced, certainly, but would I be in a position to provide an informed response as to the risks within the casino sector at this stage? Probably not.
Has your work as a government regulator generally led you to believe that an essential aspect of risk management is a proper auditing function?
I think if you are speaking specifically to the compliance end of a regulatory delivery, appropriate compliance and monitoring programs, of which one aspect could be an audit. There are lots of other activities that you could undertake in respect of monitoring and ensuring compliance with instruments that you're tasked with regulating, or indeed with legislation that you're tasked with administering.
So do I take it from that answer that auditing can be something useful in a compliance framework, but that you don't consider it central, or have I misunderstood what you said?
No, it absolutely. Depending on the sector. So what I'm referring to is, depending on the sector that you're regulating, there are a range of compliance activities that you might undertake. And generally, auditing forms part of a broader, in my experience, forms part of a broader compliance program. So there might be a range of different compliance activities that you would undertake to deal with a particular risk or an issue.
And in terms then of an audit program where one is appropriate and suited to the work that's being done, would you agree that an effective audit program would focus on those areas where failures would have the greatest potential harm?
Absolutely, if it was a risk-based delivery, for sure.
And in terms of that response, if it was a risk-based delivery, do you have any views as to what the approach will be in your role now with the department, whether you consider that this is something which will also be a risk-based delivery in terms of regulation and compliance?
I think clearly, yes. Based on my limited time, a clear articulation of the risks within this sector are an imperative to designing an effective regulatory delivery, of which one part would be the compliance end.
The only other thing I wanted to pick up briefly from your CV is just in terms of the leadership aspect of the roles you've had previously. So at page 3, under Manager 2009 to 2016, you note that in that first dot point, you're responsible for leading the department's compliance, control, waste tracking, etc. functions, including 3 teams totaling 35 FTE. Does that mean that those 35 FTE were direct reports to you?
That branch structure was through 2 section managers. At one stage, I think it went to 3 section managers that reported to me as the overall branch manager.
And similarly, at the top of the page, I think there's another dot point talking about a total of 64 FTE that were involved in what you were leading there. Mm-hmm. What was the reporting or structure in that case?
So in that instance, I was acting for the director of our compliance and enforcement division, and that division has responsibility across a broad range of regulatory activities, including incident response. We had a team of investigators, we had a team of compliance officers, so it was a broader delivery than just compliance. We had complaint function response requirements within that division, as well as other broader work.
So how significant a component in your previous roles has a staff management function been? I commenced, I suppose, my career as an officer. And throughout the approximately 20 years I've worked in regulation, I've naturally transitioned to leadership roles, whether that's been within the team investigating particular issues. I began my career
implementing European environmental directives. So that was within project teams. And then as I progressed, particularly since relocating to Western Australia in 2012, I've held leadership and management roles in respect of regulatory delivery and reform.
Moving then on to the issue of casino regulation specifically, and you mention at paragraph 3 of your witness statement that that's not an area that you have any prior experience in, and then you say again at paragraph 10 that you haven't received any training specifically to the performance of your function as the CCO. Is that correct?
That is correct.
And you mention at paragraph 4 that you have had the assistance available to you of a consultant named Mr. David Snowden.
That is correct.
And I understand that Mr. Snowden has casino regulation experience in the ACT and is the former CEO of the ACT's Gambling and Racing Commission.
That is correct.
Now, is Mr. Snowden still working for government in the ACT, or is he now acting purely as a private consultant?
I'm unsure.
Is it your understanding that Mr. Snowden is essentially available to you to assist you and provide assistance and information at any time that you would find it helpful to speak with him?
That's correct. That is my understanding.
And your witness statement mentions that there's been 2 discussions that you've had so far with Mr. Snowden.
Yes, at the time of writing it was 2. I've had an additional opportunity to engage with David since.
And my question was going to be in relation to those interactions. What is the nature of the topics which you're discussing? What is the nature of the assistance that you're seeking and that Mr. Snowden is able to provide?
In the first instance, my engagement with Mr. Snowden was in relation to the CCO delegation. Pardon me, actually, let me correct that. My first engagement was by way of introduction. So we had an introductory meeting. The second engagement I've had, I reached out to David to discuss the CCO delegation as it stood.
And then you said there was a third one quite recently?
Third, has been an extension of that conversation around delegation, and then particularly looking to supporting information around executing delegated functions in respect of the CCO. So based on my experience in holding similar kind of delegated responsibilities in other legislation, instruments of delegation are generally supported by a range of policy and process around how those delegations will be executed. I sought David's advice in terms of what that could or should look like in this instance.
All right, I'll come back to the delegations issue in a little more detail later. But for the moment, are you satisfied with the level of assistance that you are receiving from Mr. Snowden?
Yes.
Then before I ask you some more questions about your role as CCO specifically, I'm just going to ask you about your role as ED RGL. In broad terms, is that role of being the Executive Director, Racing, Gaming and Liquor, roughly equivalent to what would have been the DG while that was a separate department, or is it a different type of role?
I'm unable to provide a response to that in terms of my knowledge about what the former structure was in terms of the DDG role.
Well, let me ask you perhaps some questions that then pick up on what is in the job description form of the role, and that is at DLG.001.0011.008. And you can see down the bottom of the page, there's the purpose of the position, and that first sentence, that the ED is responsible for regulatory oversight and building the capacity, outcomes and integrity of the racing, gaming and liquor portfolio. Then if we go over onto, I think it's page 3, we have the duties of the position. And I'll just give you a moment to read through those, looking in particular at duties 1, 2, 3, 6 and 7. And the question I have is that all of those are expressed, as you would expect with a JDF, at quite a high level, and they focus on the strategic aspects of the job. But can you assist the commissioners by giving a more practical day-to-day sense of what is involved in the position that you have taken on?
Okay. Based on my, I suppose what I would say before I answer that question is the 7 weeks that I have been in the role have not been what I would consider a typical operating environment. It's quite a disrupted operating environment. So what I've done in the last 6 to 7 weeks is probably not representative of what I would consider a typical time in a role like this. So at an executive director level, my my role, as I see it, is to oversight the day-to-day delivery of the regulatory functions for those sectors. In practical terms, that looks like there are 3 branches within the racing, gaming and liquor division. We undertake a range of assessment functions at the front end, both in the gaming and wagering sector, but also in the liquor sector, across casino, but also the broader gaming and wagering, community gaming, racing. We then have a second branch that looks at the more complex assessments in liquor and also has the compliance and monitoring functions broadly across those sectors. And then the last branch within the division is what's referred to as a strategic regulation branch. So they do a lot of work around policy, around legislative reform, and particular projects around the different regulatory deliveries. So my time in the last 7 weeks has been predominantly spent really bringing myself up to speed with the current legislative frameworks, the current regulatory deliveries, but also the operational and business processes that support those deliveries.
Mm-hmm. And in terms then of the reporting lines that are coming to you at the moment, how many people are direct reports to you, and particularly what level of interaction do you have with people who are carrying out an inspection function?
So currently I have 4 direct reports that come directly to me. That director of industry licensing is that front branch. We have the director of liquor and arbitration, the director in the strategic regulation branch, and recently established is the GWC Secretariat, and the general manager reports through to me. In terms of the last 7 weeks, I have spent time engaging with all members of the racing, gaming and liquor division. So I've held one-on-ones with all staff members in that division as part of my journey of discovery, I suppose, to understand the operation of the division. I've also held a range of meetings with the senior leadership teams from across those branches, which include our compliance functions. And I've also held dedicated meetings as part of that cascading engagement with the compliance team in particular. But that's part of a process where I'll meet with all of the teams in the division to understand their business in more detail, and obviously to understand more about the people that I'm responsible for leading.
And then the last question I had, with respect to your role as EDRGL, is a comment that you make in paragraph 52 of your witness statement, where you explain that you're in the process of restructuring the compliance functions within the RGL to delineate between various programs, casino, community gaming, racing and liquor. Can you explain, for the benefit of the commissioners, in a bit more detail what you mean by that restructure?
So this was a topic of conversation that I had with Lenny Chopping as the Director General in terms of that pre-briefing, in terms of before I took on the job. But then in looking at not only the gaming and wagering sector itself, but obviously the liquor sector, and then when you dissect gaming and wagering in a little bit more detail, you have obviously the casino, community gaming and racing. So based on my experience, my preliminary observations were those sectors are quite different in terms of their risks, potentially, when I learn a bit more about it, but on principle and on the face of it. So the compliance programs that you would undertake and activities that you would undertake would be quite different. So there is merit, certainly in the interim, while the longer term regulatory reform for both the gaming and wagering sector and obviously the division as a whole is considered and progressed to really delineate between those sectors and to really make sure we've got a clear understanding and articulation of the risks, and then the compliance activities that we are doing are fit for purpose.
So in terms of that delineation, the particular question I have in relation to that, with the notion of having people separated, will there be, from your perspective, inspectors that are dedicated casino inspectors? And if that's the case, again, it might be too early for you to say. If that's the case, what is your view as to whether those inspectors should have a full-time presence at the casino?
I think it is too early based on my 7 weeks. We're certainly exploring all options, and again, in my experience, a clear understanding of the risks that you're looking to address in the sector will inherently inform how you set up a compliance delivery. So that's based on my experience in compliance delivery outside of this medium. So as to the presence at the casino, certainly that is something that we'll look at. So I don't have a view at this stage.
So you've obviously had a bit of experience in your career thus far, being involved in projects for reform. As a result of the experience you've gained there, are you able to hazard a guess or an estimate as to when you will be in a position to have a firmer view as to how things might move forward?
Certainly in the interim, the discussions that we've had to date, I'm hopeful within the next 4 weeks in that interim space around any interim measures we take in our compliance functions. I'm hopeful to have that view and a way forward really kind of considered within the next 4 weeks. But then obviously looking to the longer term regulatory reform of gaming and wagering regulation more broader. What we do in the interim will obviously feed into that longer term plan. So
changing tack now to ask you some questions about your role as the Chief Casino Officer. You say at paragraph 16 of your witness statement that before you commenced, you were not given a specific information pack and you requested and were provided with various materials for you to consider. Were those materials all provided after you came to the department? Yes. And so, to what extent did you have any understanding of the role of CCO before you commenced, or has it all been something which you have been learning about on the job, so to speak? I think it's fair to say that I've been learning since I came on board. And then you explain at paragraph 18 that you've had a number of meetings with the prior CCO, Ms. Nicola Perry, for briefings, and then more generally met with the senior staff of the RGL to acquaint yourself with the role. As a result of your reading of the legislation and those meetings and briefings, what is now your understanding as to what the role of the CCO entails? So my understanding of the position itself is that it's a position established to assist the Gaming and Wagering Commission in the administration of its functions. The role itself, so since I came on board 7 weeks ago, I've sought to understand a little bit more about that legislative framework. I've sought to gather as much information as I could from departmental staff about what the practicalities of that role are. I obviously looked at the existing delegation, and then through inquiries in a variety of meetings I've had with the former interim CCO, I sought to familiarise myself with the actual day-to-day kind of operations, I suppose, of the CCO. And again, I appreciate that many of the questions I'm asking you may well be answered with "it's too early to tell." But at this stage, are you beginning to gain any sense as to what the focus of your role will be in the months ahead as CCO? Certainly, as I outlined in my statement, there was a lot of consideration for me in the last 7 weeks about the delegation. I formed the view probably early on in the last 7 weeks that there wasn't a clear picture for me of the Gaming and Wagering Commission's current position in respect of the CCO delegation. This was through information I gleaned through meeting with the interim CCO, and then subsequently a review of minutes from Gaming and Wagering Commission meetings that I didn't attend. So I formed the view that I needed to seek clarity from the Commission as to their current position in respect to the CCO delegation. I sought that clarity at the Commission's August meeting and prepared a paper to that extent, which has resulted in a revised, reduced CCO delegation being endorsed by members, which will provide me with a very clear understanding of what the Commission want me to do in the very immediate, which is focused on, I think off the top of my head, I'm drawing a little bit of a blank. It's around casino licensing, employee licensing, and another
element which refers to the purchase of casino equipment, I believe.
Now, the way you explained that was that you formed a view that there were some issues, and then you put together a paper which went to the GWC.
Mm-hmm.
Now, the way that you describe it makes it seem as if the role, or that part of your role, was quite self-directed, in the sense that you recognised a problem and took it upon yourself to deal with that problem. Is that so far your experience of what it entails to be the CCO, to largely be a self-directed person, or do you receive direction from the GWC?
The preliminary, I suppose, based on my time, my preliminary observations would be that the CCO, as the position is articulated in the legislation, is there to support the Gaming and Wagering Commission. Therefore, I think it's incumbent on me as the CCO to clearly understand what the expectations from the Gaming and Wagering Commission are. I don't think that's limited, while the delegation in question at the moment is limited. I have no kind of view as yet whether that is the sole expectation of the Commission in terms of my execution.
Well, perhaps to ask it a slightly different way, have you yet received any specific direction from the GWC asking that you undertake a task or carry out an investigation or do a specific thing? Has there been that level of specific direction that you've yet experienced?
Given, I suppose, the short tenure I've had in the position, I've been to 2 GWC meetings, the first of which was the introductory meeting in July. So I don't believe I have been substantively directed by the Commission to undertake any activities in the CCO's role as yet.
All right. So just then in relation to your role as CCO, we've previously talked about your role as ED and the people reporting to you. Are there people that report to you as the CCO in that role?
No, the line management comes from my position as ED RGL.
Okay.
That's my understanding.
And I think the answer to this question may have already been answered by what you said previously about your interactions with the GWC and it being very early days still. But to this point, do you consider that the GWC has exercised any oversight over you in respect of setting expectations and then following up and monitoring your progress and performance?
I think given the relatively short period of time, I can't really say. Certainly in the first meeting, members of the GWC questioned my experience and I provided an overview of my experience.
At paragraph 19 of your witness statement, you make a comment that you consider from your observations to date, there appears to be limited procedures and policies in place as to the exercise of powers and the discharge of responsibilities in relation to Perth Casino. And that's in the context broadly of saying what the existing GWC's policies are. Do you suggest by that comment that in your view there should be such policies and procedures in place to guide your function, the GWC's function?
Based on my experience, I suppose, to date as a regulator in a range of different mediums, typically I would expect a very clear, what I'd refer to as a regulatory system. So a very clear articulation of the legislative objectives that you're there to achieve, a clear understanding and articulation of the risks, and then that's supported by a regulatory model that's very clearly articulated and defined. That regulatory model typically has a range of policies, like a compliance and enforcement policy, like a clearly articulated regulatory approach that makes it very clear to all stakeholders how the regulator undertakes its functions. And then operationally, that delivery is supported by a range of procedures and manuals and standard operating procedures. I'm still on a journey of discovery, I suppose, given it's 7 weeks. It's 7 weeks, but my preliminary observations are that those things are not quite what I would be used to in terms of regulatory delivery. So there are gaps, and certainly they've been identified in the work programmes that we are developing moving forward.
You made a comment there about being supported in your delivery of services. One thing we heard earlier this morning when Ms Chopping was giving evidence was in relation to the new Secretariat function with the GWC, with, I think it was Ms Sophie O'Keefe, I think, is in the role. And that was explained to us as being a role to assist the GWC. Do you have any interaction with that role? And if so, what is the nature of that interaction?
So Sophie O'Keefe is one of the direct reports that I referred to earlier. So the broader, and this probably comes to my preliminary observations of the role of CCO and the role of Executive Director, Racing, Gaming and Liquor. In my role as ED, I'm responsible for the regulatory delivery of the gaming and wagering sector and the liquor sector. So I'm responsible for a broader range of activities that are undertaken to support the GWC, governance and secretariat being one of the newly established ones, but also then the compliance programs and whatnot that don't operate under the direction of the CCO, for example. So I see the role of CCO and Executive Director, Racing, Gaming and Liquor relative to the gaming and wagering sector regulation as not necessarily mutually exclusive. The ED has broader responsibilities in terms of GWC Secretariat, the broader compliance, but also supporting the GWC, is my understanding, in policy development and whatnot. So the role is broader than what's currently delegated or considered in the CCO space.
Just staying with Ms O'Keefe for a moment, you explained that she was one of the direct reports to you, and one of your earlier answers, you explained that no one reported to you in your role as CCO. So does Ms O'Keefe report to you as EDRGL? And that is notwithstanding that she is essentially dedicated as a GWC Secretariat.
That's correct.
So, if you like, there's a bit of a merging of those streams. A GWC person is reporting through to a departmental hat that you're wearing.
Well, a departmental person is reporting through to a departmental person. So Sophie is employed by the department.
And am I right in thinking that Sophie's sole role is to act as the executive manager or general manager of the GWC?
That's correct.
Yep. Then just in terms of some questions about the nature of the relationship between the CCO and the GWC as you understand it, and in particular, do you have a view as to whether under the enabling legislation, the role of CCO is one that is obliged to follow directions from the GWC?
In so much as, I'm sorry, could you repeat the question actually?
So I'll phrase it this way. If the GWC was to give you a directive in relation to carrying out a task or work for them relating to casino regulation, for example, or gaming regulation more broadly, and were to charge you as the CCO to carry out that work, would you consider that you were obliged by the Casino Control Act to carry out that work?
Yes, I would.
And in terms of the way that legal obligation is currently structured, I can take you to Section 9 of the Casino Control Act if that would be useful, but the language of it is not express. It doesn't state that the CCO must follow directions or words to that effect. Do you have any uncertainty or doubt in your own mind as a result of looking through the legislation as to how that relationship functions?
I would agree that it would benefit from more specificity. I think it's administrative. I think the line from memory is provide administrative. Actually, if you could bring up the legislation, that
yes,
would
of course.
be helpful.
So we'll bring it up now. It's PUB.0004.005.001. And if we can please go to page 12. So section 9.1. I'll let you read that through.
Yes. I just didn't want to ad-lib, but yes, administrative and other services. So it certainly could benefit from some more specificity.
Yes, the way it's framed doesn't expressly say what your role is or how your role is to work with the GWC. So you would consider that would be helpful to you in fulfilling that task as a CCO, to have a clearer definition of that role?
Yes, I would agree.
Then moving away from the legal question and towards the more practical aspects of the relationship between you and the GWC, you have mentioned that you have attended some GWC meetings, I think the two most recent meetings.
Yep.
Are those the only occasions on which you have had interactions with GWC members?
Yes, face-to-face, yeah.
And that first meeting, when you had a chance to meet everybody, had that been preceded by any out-of-session communications, emails or phone calls?
From me directly?
Yes.
No.
And have there been any subsequent out-of-session communications, emails, phone calls, or the like, with you and GWC members subsequent to you first meeting them at the first meeting?
No.
Do you have any view as to whether that is an appropriate or helpful way to manage the relationship between CCO and GWC, if it's something which is done through formal meetings, or would it be something where you consider to be of assistance to have more regular informal contact as well?
I would think based on my limited tenure, I suppose I don't have an informed view of that, given the last 6 to 7 weeks are not what I would consider a normal operating environment. Probably the other element to this would be an understanding of the service level expectations broader than the CCO delegation, but a clarification and understanding of the service level agreements between the department and the GWC would certainly help in clarifying what I would consider to be a normal operating environment.
Now, we've heard some evidence earlier today from Ms. Chopping as to how work is being done on those service level agreements. Could you just give the Commissioners your own understanding as to how the department will deal with the issue of being able to quantify and then provide services in the future?
So I can provide an overview of the range of work, I suppose, that's underway at the moment in respect of a number of issues really around legislation, regulation, but also governance. So there have been a number of work programmes commenced, one of which focuses on a forward programme for GWC governance. So a lot of that work is around the actual operation of the Commission. So governance around right down to kind of organisation of meetings and papers and kind of the more practical governance elements, right to service level agreements, considering cost models and whatnot. The second kind of work in train really is looking at gaming and wagering regulation more broadly, and what I would consider really a kind of a regulatory reform roadmap for the sector. The third programme of work is in response to the internal review by the department on the gaming or the RGL division. The RGL division.
Is that the internal review that was conducted by Ms. Roach?
Yes, that's correct. So we have a range of work programmes in train that really will help to solidify and clarify what I would consider, again, the regulatory system around casinos, but also gaming and wagering more broadly.
I just wanted to ask you some questions now in terms of the process of balancing those roles as ED, RGL and CCO. And I think you make the point in your witness statement at paragraph 13, you deal with the time balance at the moment. You say 70% gaming wagering, which might be unusual, and 30% liquor at present. And then you go on to make the point at paragraph 14 that this includes time focus on GWC governance as well as providing support to the department, the GWC's response to the PCRC. So there are a few different tasks that are intermingled, if you like, in the way that you're assessing your work, which relate both to departmental activities and to activities for the GWC. Would you agree with that?
Correct, yep.
And those comments are being made under a heading, a paragraph heading, which is just above paragraph 10, which is role of the CCO. And I'll just let that go back one page, please, to show paragraph 10. So you can see there you've got roles of the CCO questions 5 to 7 at paragraph 10. And then you go on to talk about the work that you're doing essentially both as CCO and also as ED RGL. And so my question at a high level is, at the moment, do you find that the work that you're doing has a tendency to perhaps merge the functions and the activities that you're undertaking as ED and also that you're undertaking as CCO?
Again, I suppose, given the relatively short tenure of 7 weeks, I don't think I can provide a meaningful response. It's quite a disruptive time with lots of different things happening. So I don't think the last 7 weeks is a representative kind of example of how the role of CCO and the role of ED RGL work in what I would consider kind of a normal operating environment.
And that difficulty that you're having at the moment to express how things might be longer term may also impact upon your answer to my next question, which was going to be to take you to paragraph 41 of your witness statement, where you talk about your responsibilities as EDRGL. And in the middle of the paragraph, I think it's the third sentence, so you've explained a bit above what your role entails. Then you say, further, to the extent that the CCO does provide administrative and other services, the GWC, that function is also served by the EDRGL. So again, there seems to be reference to the kind of work that you're doing overlapping in the two roles that you're performing, perhaps because those roles are pulling together in the same direction to achieve the same outcome. But the way that you're describing your work seems to suggest that there is not a clear delineation in your own mind at all times between CCO work and ED work. Is that fair? Am I reading too much into that sentence?
I think it might be a little bit of a stretch. I suppose my preliminary observations are I see the CCO and the ED, and I keep referring, I suppose, to a regulatory system. I don't see those roles as mutually exclusive. I see them as complementary, with the remit of the executive director encompassing broader functions for the GWC relative to the role of CCO. So I think I don't see them as mutually exclusive, but I don't think, given my 7 weeks, I can provide a probably meaningful response at this stage.
Understood. I'll explain where I'm trying to drive at, and that is, if you go to paragraph 9 of your statement, you talk about the possibility of how to deal with competing priorities. If there were competing priorities between your role as ED and your role as CCO, and the language you say there is that, let's see if we can find it. So middle of the paragraph, beginning of the words, if competing priorities arose between gaming and wagering and liquor, it may be more problematic. Mm-hmm. And obviously I take it from the language if that you haven't yet encountered a situation where you considered there was any kind of conflict.
That's correct.
But you consider, or you acknowledge it would be at least possible that there might be a conflict situation that could arise in terms of demands in your time, in your CCO role and your ED role.
Could you rephrase the question, please?
Going back to one of your earlier answers, you explained that you understood that the GWC could issue directions to you. Mm-hmm. So it's at least possible that the GWC might issue with a direction to carry out a certain task. You might be given a task by the DG at the same time to do something else, and there might not be enough hours in the day to do both.
Yeah, I think it speaks, as well as indicated in my witness statement, I think it speaks to the actual construction of the RGL division as it stands now as well, because it's what I would consider an integrated model. So you have the same officers, both from an assessment perspective and a compliance perspective, working across liquor regulation, casino regulation, community gaming regulation, and racing. So there's a broader issue, I think, around competing priorities between liquor. That's not under the remit of the GWC, and obviously the other gaming activities and wagering activities that are under the remit of the GWC.
Right. Now, appreciating it's too early for you to be able to draw any firm conclusions, that question of competing priorities, is that something which may, in your view, be assisted by perhaps separation of function or greater resources for different functions? And again, if you are not in a position to answer, then you should feel free to say so.
I really don't feel I'm in a position to answer.
Now, leaving that and going to the issue of delegations, which you've mentioned on a few occasions today, just by way of broad background, in terms of the notion of delegation, what do you understand to be the legal effect of a delegation being made from a body such as the DWC to a person in the role such as CCO? Once that delegation is made, for example, what is the manner in which the power can be exercised by the person who receives the delegation?
So based on my previous experience, as I indicated earlier, an instrument of delegation typically is accompanied by a lot of supporting documentation that articulates very clearly to the authorising environment, in this instance being the Commission, the manner in which that delegation will be executed, the considerations that the delegated officer would factor into exercising that delegation, and then the steps or the kind of standard operating procedure, I think, that goes with the execution of that delegation. That's based on my experience, that's what I would typically expect. And that provides that level of clarity and transparency, I suppose, to the authorising environment in providing and delegating, providing the instrument and delegating those responsibilities.
So your answer there has touched upon what might be called best practice as to how to exercise a delegated power. My question's a bit more basic than that. My question arises out of the fact that we see in many of the GWC agenda packs reporting from persons who have exercised delegated authority. My question is in relation to your understanding as to delegations. Is it necessary, for example, for a person to report the exercise of delegated authority before that authority takes effect? So if a decision is made by a person to whom authority is delegated, does that decision take effect immediately or only upon report back to the GWC?
I think reporting on decisions made under delegation is an integral part of an effective delivery. I don't see that reporting in advance of executing the delegation, again, specific to the type of delegation that's being exercised. So if, for example, it is quite a narrow delegation, and I'm speaking kind of hypothetically here, so if it's rather a narrow delegation or what is considered an administrative kind of delegation in nature, and the authorising environment has delegated that power on the understanding that this is how it will be executed, I think it's appropriate for the report back to be after the decisions are made. And again, relative to if it's an incredibly broad delegation that the delegated officer is seeking to exercise, I personally would probably seek, I would communicate and engage with the authorising environment before the execution of that broad. If it is a significant delegation, for example, cancellation or in my previous life, cancellation or suspension of licence, issuing of protection notices, that is certainly something that I would bring forward for discussion prior to execution.
I'm phrasing my questions badly. What I'm asking is, if you, in your role as CCO, have a power delegated to you, and you choose to make a decision to exercise that power, does that take effect immediately or only upon report later on back to the GWC?
Takes effect immediately, would be my understanding.
And further, once you've had a power delegated to you, if the GWC delegates a power to you as CCO, do they still have the power to exercise that same function themselves?
Yes, that would be my understanding.
And I only ask those questions because there's been some focus on how the report back function to the GWC works in relation to other witnesses. Now, you're aware, I imagine, from the review or from your time with the GWC that in May 2021, members requested the revocation of the delegations for the prior CCO and the prior DGs.
I have an awareness of it, having not been involved and appointed until the 8th of July, but yes, I do have an awareness of that.
Yes, and then subsequently, I'll bring up a document and show this to you and let you comment. GWC.001.00001.0603, and if we can please have up pages 35 and 36 side by side. Now this is, when it comes up, an agenda item for a meeting. You're not the author of this document, but I wanted to ask you some questions about the way it deals with delegations to dig further into this delegation issue. So under the current situation heading, that first paragraph, there's a discussion about what is the effect of the appointment of a new person as CCO and an apparent automatic cancellation of prior delegations. You see that?
Yes, I do. Yep.
So just to explore that issue a little bit further, I'm going to go to that previous CCO delegation, which I think is at pages 54 and 55. And you can see, looking at the introduction to this instrument of delegation, that there's a statement that it replaces prior interim delegation. And then it goes on underneath that to say that the delegation is made to the holder of a position. So is it your understanding that where a person has been in a position and powers have been delegated to that position, is it, in your view, correct to say that the appointment of a new person in that position has the effect of cancelling the previous delegation? Or is it more accurate to say that the person who is coming into the position takes the powers that have been delegated to that position? So I'm really asking you to focus on that word that was said in the previous agenda item about cancellation of prior delegations and whether you agree with that way of articulating it.
My understanding in this particular instance, so my awareness, I suppose, of the papers that were prepared for the previous commission meetings was as part of my due diligence in understanding the current situation in respect of the delegation. I made inquiries with departmental staff about the discussions at the May meeting, but also at the June meeting. Those inquiries indicated that advice had been sought and received, I think, from internal legal at the department about the delegation sitting with the position rather than the person. So I think, again, understanding from the inquiries that I undertook, I was advised that the position or the view was formed that the delegations for those gentlemen in question did not need to be revoked by virtue of the fact that they had, I think it was in respect of the Director General had left and whatnot, and then the appointment of Nicola coming in to replace Mark had essentially dealt with those gentlemen being in that position. However, as to the appropriateness of the delegation sitting with the position from a legally robust perspective, I can't provide.
But perhaps don't need to go down that line
okay.
any further. So I'm interested in your answer there that you did seek advice as to how the delegations would work, and you received advice about what would be an appropriate way of framing the delegation.
Yes.
In that case, I won't take that any further. I do have a single question, which is something of a detour. If we can please bring up GWC.0012.001.0250 and have pages 1 and 2 side by side, please. And when this comes up, this is the agenda for the August meeting, which I understand considered your paper in relation to the delegations. And I just draw your attention there to page 2, which is the agenda item 12, and that's dealing with FPOS and contactless payments. And if we can then please bring up, having looked at that, GWC.0012.001.2588. Which I think is the paper that you drafted dealing with the delegation, is that correct?
Yes.
And I just wanted to understand why it was that this is also agenda item 12, but is not the agenda that seems to have been before the GWC.
Yes, we had a last minute adjustment to the agenda. So the original agenda item was withdrawn and replaced with this agenda paper. And then we provided advice and an updated agenda to members. So it was a last minute adjustment to the paper pack.
And that perhaps gives me an opportunity to segue for a moment to ask, what is currently happening with the process of getting agenda items and information to GWC members? What's the time frame that they have to consider before receiving information? Can you give us any update about that? Mm-hmm.
So typically, I say typically, in the last 7 weeks, typically we try to get agenda papers together and transmitted to members in a reasonable time frame, be it 3 to 5 business days. But as you can see from the agenda paper that you brought together, they are pretty significant volume, I suppose, in terms of an agenda structure. So it's been a little bumpy, would probably be my assessment since my time, and certainly since Sophie has come on in the general manager role. We've looked to try and streamline and restructure the agenda to try and make it simpler for members to navigate through the vast array of things that are on the agenda. But we look typically 3 to 5 business days, I think. But there is a significant volume of information in the two meetings that I've attended. They are significant meetings. They take 3 hours, the last 2 meetings in particular.
And they're held on Fridays, is that correct?
I think the last one was held Friday, but I think it moves depending on availability, but monthly.
And I'm just wondering, in terms of that 3 to 5 business days, is there always a weekend in between for members to have the opportunity to consider the paperwork?
Having been involved in 2 meetings, I'm not sure I can really provide a response there.
The last series of questions I wanted to ask you about, to change tack now, is in relation to your interactions with other jurisdictions. And you mention at paragraph 32 of your witness statement that you've had some meetings with casino regulators from other jurisdictions. The first one you talk about is on the 29th of July, and that was what you say was an inter-jurisdictional casino liaison meeting, which you say is an operational forum for casino regulators. Can you tell us a little bit more about that body? Is it a formal body for regulators, or is it an informal officer-to-officer level interaction?
I'm not 100% sure. I think it is, so it's not at an officer-to-officer level, it certainly is at CEO, a senior level. So it is a forum for engagement at a senior level for casino regulators across in different states to engage on issues and common problems from my first meeting.
Are you aware of how often it meets?
I am not at this stage, no.
And obviously you appeared on behalf of the WA regulator.
I did.
Was there anyone else who appeared with you?
Nicola Perry attended with me, given my relative, I think it was the 29th, and I had, that was my first month.
And in terms of the persons appearing from other jurisdictions, were they equivalent persons, casino control officer type persons, or who else was coming in?
From memory, there were a broad range of representatives from the other casino regulators, and a wide variety of roles. So I can't provide specifics, but it was certainly, from my recollection, at a senior level, and a variety of different representatives.
And if you're able to give a very brief summary, what were the sorts of matters that were on the agenda for that meeting?
At this stage, I don't think I could recall, with it being my first meeting by way of introduction.
That's okay.
I can't recall specifically.
The reason I asked is because the PCRC has seen some documents which suggest that at an earlier stage, a former CCO, Mr. Michael Connolly, proposed that the department explore the idea of a national framework for junket regulation, and that was at GWC.002.0016.0283 at page 43. I don't need that up on the screen, that's just for the transcript. My question is whether there was any discussion in this meeting that you had there about that proposal, national regulation for junkets.
Not that I recall.
And has that been a topic which has been raised in either that group, the Inter-jurisdictional casino liaison, or in any of your other meetings, such as with the VCGLR or the Queensland regulator?
Not that I can recall specifically, no.
And just going to then your second meeting, that VCGLR meeting, I take it that VCGLR is short for the Victorian Commission for Gambling and Liquor Regulation?
That's correct.
And are you able to let the commissioners know what that meeting was about? You mentioned national standards for ATFs. Can you give us some more detail about that?
So that was a meeting that was arranged specifically for me to bring me up to speed with the work that had been undertaken in the national standards space. So that was with 2 representatives from the Victorian regulator to really give me an introduction to the national standards.
You might not know the answer to this, but is there currently work going on at the GWC level in relation to the WA appendix for the national standards?
I can't answer that question at this stage.
And then the last question, or the last issue that you mentioned in your statement at paragraph 33, you explain that you spoke with the Queensland casino regulator, but you say that you connected digitally.
An email exchange.
Email exchange. In relation to what that was about, that communication, was that in relation to the EGM speed of play issue?
No, that was just a general introduction.
Okay. Are you, perhaps a slightly different question, but sparked by that comment, are you aware of the EGM speed of play issue?
I have an awareness of it at a preliminary level, given my relative short period of time.
And accepting that it's early days, how would you articulate what you understand the issue to be at this stage?
I don't think I could really articulate it with any sufficiency.
You've just heard the expression.
The expression, yeah.
Having gone through those interactions that you've had with the various other jurisdictions, it appears that it's reasonably common that there is interaction between the WA regulator and other regulators around the country. Is that correct?
That's certainly my impression. And in my former role, roles within the Department of Water and Environmental Regulation, certainly participation in the Environmental Regulators Network, and so I'm on the National Steering Committee for the Australian Environmental Regulators Network. I'm also a member of the WA chapter of the National Regulators Community of Practice. So I'm aware, in general terms, of a lot of interjurisdictional engagement on regulatory practice and regulatory issues. And what I've seen from my preliminary observations in this space is that seems to be the case in respect of casino regulation. There seems to be a lot of engagement across boundaries and across borders in respect of casino regulation.
And at this stage, again, knowing that's always very preliminary, have you encountered any difficulty in these interactions or liaisons as a result of legislative framework or any other factors which is in any way impeding your ability to communicate and liaise with other agencies? In the course of those interactions with other regulators, has it been necessary for you to consider the information sharing prohibitions on Section 20, subsection 3 of the GWC Act? If you haven't yet had a chance to consider that, I can bring those up for you to have a look at those.
I have an awareness of those provisions within the legislation, absolutely. I haven't been in a situation of information sharing with other jurisdictions or other regulators at this stage.
So in terms of your discussions with these other regulators, you've not had the need, for example, to discuss the activities of the casino licensee?
It was by way of, hello,
yes, okay.
Inter Markham.
The reason I ask these questions is, as you would know from the legislation, there's a general prohibition on information sharing, and then under the Casino Control Act, there's an exception to that prohibition if the information sharing is authorised by the CCO or authorised by the GWC. Are you generally aware of that framework?
Really aware of those provisions, yes.
So my question was going to be in relation then to when you're in your role and dealing with other persons, knowing that you can wear the dual hats of being either ED or CCO, whether there might be any difficulty in taking advantage of that exception for the CCO, if it's not always clear whether you're acting as CCO or ED when carrying out information sharing. Is that an issue that you have had to consider at any stage?
It's not an issue I've had to consider in the last 7 weeks. While I do have an awareness of those provisions within the legislation, and it certainly is something I would seek clarity on, both from a legal perspective but also from a Commission perspective, about how they see those interactions operating going forward. But I haven't had to do that in the last 7 weeks.
Well, that was going to be my question. How would you seek to deal with that issue? You said you'd seek clarity. What's your understanding of the avenues available to you to seek assistance or guidance, perhaps as to legal matters or otherwise, when you are discharging your roles as CCO and ED?
So from a legal perspective, I'm clear that I can seek legal advice from the State Solicitor's Office in particular on any matters both pertaining to the Gaming and Wagering Commission and the execution of functions there, but also broader in liquor regulation as well. But seeking clarity, I suppose, would also be from a legal perspective, but also from an authorising environment perspective, so from the Commission themselves, in terms of their understanding of those provisions and the appropriate considerations about when and how they would be executed. But also then from my own due diligence and judgment as a regulator to understand the appropriateness of information sharing.
All right, changing topic now and going to the question of the relationship between the regulator and the regulated entity, in this case the Perth Casino. The PCRC has previously received evidence in the course of its hearings dealing with the relationship that used to exist between a former CCO, Mr. Michael Connolly, and various employees of the Perth Casino. Are you aware of that general evidence?
I have an awareness of it, yes.
The relationship between the regulator and the casino at earlier stages has appeared at times to be almost collaborative in terms of the interaction, and that's my characterisation. My question is, how would you characterise the relationship now? To the extent that you can.
To the extent that I can, I suppose, in the 7 weeks that I've been here. Certainly, more broadly, I suppose, on the issue of the perceptions around regulated entities and regulators. There are, in my experience, a range of elements, I suppose, in contemporary regulatory practice that need to be in place to ensure you've got that clear delineation between regulated entities and the regulator. So I think I referred earlier to a clear articulation of the regulatory posture, a clear articulation of the regulatory model, principles of better regulatory practice, which are quite common, talk to transparency, they talk to consistency, evidence-based, risk-based considerations and whatnot. But there's a range of elements, I think, in contemporary regulatory practice that need to be there. And it's a sliding scale, I suppose. It's that there's a range of interventions and strategies, whether it be at an officer level or a systemic level, for the regulator to be very clear about its regulatory posture and how it executes its regulatory functions at different stages in the regulatory cycle. So a compliance posture versus a policy development posture versus an assessment posture, they're all quite different. So while I can't talk to my experience in the last seven weeks, I suppose, certainly the experience that I bring to the role is very clear about how I engage with regulatory entities. In executing any functions that I have as a regulator.
So if I can just zoom in on what you refer to as the compliance posture, do you have a view as to what is an appropriate compliance posture for a regulator to adopt in respect of a regulated entity, particularly in relation to a statutory monopoly, such as the case is here in relation to the casino?
While I haven't experienced, I suppose, in regulating in this context where you have a monopoly as such, in terms of compliance posture and whatnot, contemporary regulatory practice really looks to articulation of that in a compliance and enforcement policy. So escalating responses, how the department engages in a compliance context is generally outlined in major regulators through the articulation of a compliance and enforcement policy. So that makes it incredibly clear.
Do we have one at the moment in
RGL?
No,
not that I'm aware of, no.
Sorry, I interrupted. You were saying that makes it clear?
That is a very clear articulation in respect of compliance and enforcement about the activities that the regulator undertakes in that space, how it monitors to ensure it maintains a credible risk of detection of non-compliances, and then generally an escalating kind of enforcement response relative to the breach that you're considering.
Now, are you aware of whether there's any work being undertaken to develop a compliance and enforcement policy at the moment?
Certainly in the preliminary work programme we have around gaming and wagering sector, that's something I've identified in terms of that broader work programme as is needed. And so it's certainly factored into the work programme, and it is something that I envisage going forward will be something we'll develop in this space.
Okay, now this series of questions began with a question about conflict of interest. And you've noted at your witness statement, paragraph 47, that you're not aware of any conflict of interest that you have at present. And my question builds on some evidence that we've heard from some of the witnesses, the PCRC, who've discussed what they consider to be the inevitability or perhaps the high likelihood of there being relationships that develop and conflicts that develop when there's a regulator and a single regulated entity. Do you have any views as to whether that is something which is highly likely or inevitable, and any views as to how a regulator can guard against that possibility?
Certainly. In general terms, regulatory capture and effective conflict of interest management is something that regulators need to be aware of. It's not a static issue, it's an active issue that requires a range of strategies and interventions to ensure that it is effectively managed. And there are a range of things that I'm familiar with in my experience around right down to the basic level of communication and training, but then also about how you structure your teams. How do you rotate officers through different functions? How do you ensure, for example, peer review of decisions made, and that kind of robustness of your decision-making frameworks? So ensuring there are checks and balances in that respect, but also then in the compliance space as well. How do you ensure that any perceptions of bias or capture are clearly articulated and managed? And then certainly from an officer perspective, that the issue of conflict of interest is to the fore of their minds. And this not static. Previously, in running a range of compliance teams, it was something that we factored into monthly briefings. Has anything changed in your space? Bring this to the fore of your, because conflicts may be inherent, but as long as they're effectively managed, I think it is something that regulators need to be attuned to.
Thank you. My final question to you comes out of the document that we've already referred to earlier, which was the Roach review into the department. Now, can this please be brought up only on the screen of the witness and the commissioners? And that is DLG.001.009.0053. And if we can go to page 4, and I think I'm taking you into the forward of the report by Ms. Roach. And I'm just going to ask you to read 2 paragraphs to yourself, and I'm going to ask you a question about that. Let me know when it's on the screen.
I've got trouble for some more water. I've drank all my water. Thank you. Thank you.
So we have the forward.
Yes.
At the
Yes,
moment.
Commissioners, we are in the forward. I'm just being told there appears to be a slight technical difficulty that the document is somehow not available. This is my final question. It may be appropriate, if you consider it so, for a brief recess to allow that technical issue to be addressed.
Certainly. We will adjourn for a short period until it's fixed. Thank you.
Thank you.
Be seated.
Commissioners, thank you for that indulgence. I understand that the document is now available and hopefully displaying on your screen at present. Now, if I can invite you, Ms Larkham, to go down to the paragraph that begins with the words, "what became clear," and let me know when you've got that.
Yep. Yes.
And can you please read that paragraph and the next paragraph to yourself, and then let me know when you're done. My question is, as a person who's coming into the department from outside and with fresh eyes, have you recognised some of the difficulties or challenges described in those paragraphs in the course of your secondment?
I have.
And from your perspective, are those difficulties or challenges impacting in any way on the ability of the department to provide services and support to the GWC? And if so, how?
My preliminary observations in this space probably relate to a lack of clarity, I think. And again, all of those elements I talked to about what I would consider necessary for an effective delivery as a regulator, I think are compounding the issues that staff are experiencing. So I think a lot of that high-level understanding of objectives and risk and that clear articulation of the system as a whole is not there, and it's not readily available for staff to see where they fit and how the work that they do contributes to the objectives for the Commission. So I think there's always challenges in terms of resourcing and whatnot, but I think based on my 7 weeks, I think there is this lack of clarity that is really compounding issues for officers within the division to really clearly see this is where I fit, this is the regulatory delivery, this is the objectives we're seeking, and that sense of pride, quite honestly, that says this is the work that I'm doing to achieve this outcome for the community in Western Australia.
And again, this might be a question it's not possible for you to answer, but in the short time that you have been there, and of course we've heard today from Ms Chopping, who's also a new person there, do you detect any change in those challenges that are described in those paragraphs? Essentially, are things moving in a good direction or a bad direction since you got to the department?
Well,
in your view?
I'd like to say a good direction, of course, being 7 weeks into, but I certainly see a change. I very much enjoyed meeting with all of the staff in the division. There are a lot of highly capable, very passionate people in the division, and I'm really excited about working with the Commission and obviously with and the department to kind of bring it forward so we can really provide that clarity for them.
Thank you very much. No further questions, Commissioners.
Thank you, Mr. Lee. Does any council have questions? No. All right, thank you.
No, not from me, thank you.
I just have a couple of questions, Ms Larkham. You spoke about audit being one of the activities of a compliance program. Could you just name the others? You may have during the course of your evidence, but I just want to make sure that I understand what activities you were referring to.
So within a compliance program, you can look at, for example, inspections, so face-to-face inspections, audits. From my experience in compliance, and I think probably the term audit program and compliance program are probably interchangeable. Audit in my experience, is a more in-depth look at a particular issue. Whereas inspections can be a variety of different types of inspections. They can be face-to-face inspections. They can, I think, inspections, reviews, audits, spot checks as well. So kind of, there's lots of different types of activity. There's education activities in a compliance program. So depending on the issue that you're seeking to address, you might undertake a range of education activities. So broadly speaking, when you have a clear articulation of the risk that you're trying to identify, a broad articulation of the risk that you're dealing with, you can look at a range of activities to ensure compliance with the legislation and ensure that risk is mitigated.
In respect of the, I'll call it compliance program that exists currently, have you been there long enough for you to be able to talk about its strengths and weaknesses?
I have an awareness of it, but the extent that I've been able to interrogate it and really form an informed view as to the sufficiency of it, I think it's too early at this stage.
In respect of the interaction between the regulator and the Perth casino, we've heard evidence that there were operations meetings that took place monthly between between the department stroke GWC officers and the Perth casino. Have you attended one of those operations meetings, and do you know whether they're still continuing?
No, and I do not.
How much contact have you had with officers from the Perth casino?
Limited or none. In the time that I've been there, we've received a range of correspondence from Crown on a range of matters, but in terms of direct interaction with Crown officers, none in the time that I've been in the role.
Thank you. Those were the questions that I had. Yes, Ms. Seawood.
No questions, thank you.
Thank you. Ms. Larkham, that concludes your evidence this afternoon. We will keep the summons in place because it is possible that you will be called back. Maybe that in a couple of months' time we would actually be assisted by hearing more from you, but that will be a decision that we will make in due course. But for the time being, you are free to leave. Thank you. Just before you do, there's one housekeeping matter that I have to deal with. CRW.700.062.1037 is an EGM video demonstration. An order was made prohibiting the publication of that demonstration. I hereby lift that prohibition or order, and for Council's benefit, this demonstration is not the subject of an application for a non-publication order by any party. The non-publication order was made by the PCRC of its own volition. It turns out that the order was made in error, and so it's now been lifted. So thank you very much, Council. We will now adjourn until 10 a.m. No, we won't. On Monday.
Monday.
On Monday, yes. Thank you.